Well, good afternoon, everyone. We still have a few folks joining us, but in the interest of time, I wanted to go ahead and get started. So I'm Stephanie Otts. Thank you so much for joining us today for our second webinar related to the CARES Act. I know that many of you are getting lots of questions just like we are. And so we hope that this information is helpful. One thing I did want to clarify is that we are limiting the live versions of the webinars to Sea Grant Extension or Sea Grant personnel and NOAA representatives, just for security purposes and also to make sure that we don't go over our limit. But you are free to share the resources with any of your stakeholders and constituents once the video is posted. So we do plan on posting these by the end of the day. And so we definitely want the information to get out there. We're just trying to control access to the initial live webinar. So with that, just the overview for the webinar today. We'll do a bit introduction and background just in case we have some new folks on that aren't familiar with the National Sea Grant Law Center. And then the three provisions that we're going to talk about today are unemployment assistance, paid leave, and the employee retention credit. And then we will have a question and answer session. We will try to answer as much as we can here live. And if there are questions that we don't know the answers to, we will do the research and post them in the question and answer document after the webinar. So just briefly who we are. So the National Sea Grant Law Center is one of 34 Sea Grant programs. We're based at the University of Mississippi School of Law, and we were established to provide non-advocacy, legal research, outreach, and education services to the Sea Grant network. And so at the National Sea Grant Law Center, there's myself, and there are three other attorneys, Tara Bowling, Catherine Janessi, who you heard from last week, and Zachary Klein, our Ocean and Coastal Law Fellow. So Tara and Zachary will be presenting information today. So you will get to know them as well. And we're conducting some of our outreach in partnership with the Mississippi-Alabama Sea Grant Legal Program. And Christina Alexander is the research counsel with that program. Just because I'm sure this is fresh on everybody's minds, we are not talking today about the SBA program, so the Paycheck Protection Program or the Emergency Income Disaster Loan Program or Emergency Disaster Income Loan, partly because the Small Business Administration announced last Thursday that they were no longer accepting applications for the programs, and that's because the funding had run out. The Senate did pass a bill yesterday to provide additional funding for these programs. That bill still needs to pass the House. Details are forthcoming. News reports indicate that $60 billion of the additional funding will be set aside for underbanked businesses, although that hasn't been defined yet. But additional funds are unlikely to last long. So if you are getting questions from your stakeholders at this time, a couple things to mention to them. One, the interim rule from the Small Business Administration made it clear that you can only apply for one PPP loan. So if somebody already has an application in the works, in the sense that maybe they submitted it to their bank, but the bank wasn't able to submit it to the SBA, they can't submit another one. So if they have been working with the bank, it would be important right now to contact the bank and check on the status of the application. Some banks are prepared to send it to the SBA as soon as the portal opens again. So it may be that the application is already in the works. But if they are considering doing a new one, they need to be working right now to get their application and documents together. So just this morning, we released some new quick take slides on loan calculations for independent contractors and the self-employed. So those went out on our social media this morning, and they're posted on our website. So if you do have folks asking questions about that, there is some more information available. Recipients, so if you have anyone who has received an EIDL or a PPP loan, they need to be paying close attention to the SBA guidance regarding forgiveness. Interim rule has added some detail and some confusion, so the National Sea Grant Law Center will be tracking those developments as well. But because the bill just passed and we don't have a lot of information, we aren't focusing on that today. Today, we wanted to talk about some of the other relief programs that haven't been getting as much attention, and to provide a little more detail about those. And so with that, I'll turn it over to Tara to talk about unemployment.
Hi, everyone. Yes, today I'm going to talk about the CARES Act unemployment benefits expansion. There are 3 programs that are available. First, there's the Pandemic Emergency Unemployment Compensation Program, which provides up to 13 additional weeks of federally funded unemployment benefits for individuals who have exhausted their regular unemployment benefits. Then there's the Pandemic Unemployment Assistance Program, which provides up to 39 weeks of federally funded unemployment benefits from January 27th, 2020 through December 31st, 2020 to individuals who are not typically eligible for unemployment benefits. This includes independent contractors and sole proprietors who have become unemployed as a result of COVID-19. And then finally, there's the Federal Pandemic Unemployment Compensation Program, which provides an additional $600 per week for individuals receiving regular unemployment benefits, PUA or PEUC, and that begins March 29th and goes through July 31st. And today we're just going to focus on these bottom 2 programs, PUA and FPUC. Okay, we can go to the next slide. Okay, so what does it mean to be unemployed as a direct result of COVID-19? As you can see, there are a variety of reasons why unemployment may be deemed to be a direct result of COVID-19. It can be from you being diagnosed yourself to having a member of the household diagnosed. Maybe your place of employment has closed as a direct result of COVID. And you can just look through these and see if you think you might apply. Then we can move to the next slide. So if you do think you qualify, what's the next step? Although the programs that I've mentioned are expansions of federal law, they will be administered through the states. So individuals will need to apply directly with their own home state to get the benefits. And each state's application process will be different. And many states are still working on getting their systems in place to accept and process these PUA unemployment applications. States have faced a variety of roadblocks in doing this. For one thing, current systems were not designed to process unemployment claims for independent contractors. So states must either update their current systems, which might be using old software, or they have to build separate systems from scratch. And then another hurdle is that many of the state offices are now just really overwhelmed with the sheer volume of claims that they're receiving. So the benefit amount that individuals will receive is also based on state law. Each state will calculate this differently. However, the CARES Act has established a minimum weekly benefit amount, and that's half the average uninsurance benefit provided by the state. And typically the state has established a maximum that is allowed for unemployment claims. And the state also establishes the length of time that individuals may receive unemployment. And then finally, even though states are at various stages of processing these claims, the benefits are retroactive. PUA is from January 27th and FPUC is from March 29th. excuse me. So, as I mentioned, the states are in various stages of being able to accept and process these claims. So I kind of broke it down into three basic categories of where they are. First, there are the states who are currently accepting the PUA applications through their regular system or a new PUA system. Then there are the states who are asking claimants to file through their regular unemployment insurance benefit system to get denied and then apply through PUA system when available. And then finally, there are states who are saying, please do not apply through our system, just wait and apply when the PUA system is up and running. And if you go to the next slide, you can kind of see, I looked at all the different states with Sea Grant programs to see kind of where they are in processing these applications. As I noted at the bottom, this list is current as of Monday, April 20th. States are working as rapidly as possible to get their programs up and running. So it's highly possible that this list is already a little outdated, and hopefully it will become rapidly outdated as more and more states are able to process these claims. So then if you go to the next slide, you can just see a visual representation of where the Sea Grant states are in processing these claims. The green ones are ready to go. The yellow ones want you to go ahead and apply and then get denied. And the red ones are asking you to wait a little bit. Okay, you can go on to the next one. There is a hypothetical here, just talking about what might happen if you apply for PUA benefits. So just say that on April 1st, you've lost your income due to COVID-19. The system's not available until April 21st. You apply then. And then on April 25th, the state approves you to receive $300 per week under PUA from April 1st through December 31st. You'll automatically receive the $600 per week from FPUC from April 1st through July 31st. So your first check that you will receive is retroactive to April 1st, which is your first date of unemployment. So it'll be for a total of $2,700, $300 from PUA for the first 3 weeks, $600 from FPUC for those first 3 weeks. And then the checks remaining through July 31st each week will be $900. And then after FPUC runs out, the checks would be from August through December 31st, $300 per week. And then finally, just some recommendations on how to move through the process. The first and most important thing is to go ahead and gather documentation. States are asking for all different things. These are just some examples of what states might require. Your driver's license, proof of Social Security, proof of income for 2019 through 2020 is really important. 1099s, last year's income statement, bank statements, any other documents that substantiate self-employment. So as I mentioned, just check your state's unemployment site often. Things are changing rapidly, and be persistent, but be patient. And then you can go to the Department of Labor website for any updates or more information.
Great. Thanks, Tara. This is Zach. Stephanie mentioned at the top of our webinar, I'm the Ocean and Coastal Law Fellow here at the Law Center. I'm going to be speaking to you about 2 topics. First, paid leave under the Families First Coronavirus Response Act, and then the employee retention credits that are set up under the CARES Act. So first, we're going to talk about paid leave. The FFCRA's paid leave provisions apply to employers with fewer than 500 employees. Note, however, that there are exemptions for employers with fewer than 50 employees. They can be exempted if compliance with these paid leave provisions is going to disrupt or effectively totally ruin their business. There is going to be some further clarification of quite what that means, but for now, that's all we have. For the self-employed who this might apply to, there are tax credits for mixed work, which we are going to come back to. In terms of what the employees are eligible to receive, if they do in fact work for an eligible employer, it'll be up to 2 weeks of paid sick leave at the employee's regular rate if they're unable to work because they're experiencing COVID symptoms or they're quarantined. So that's up to 80 hours paid sick leave at the regular 100% rate. If they're going to be unable to work to care for someone else who's subject to quarantine or who's experiencing symptoms, or to care for a child who's under the age of 18, whose school or child care provider is closed or unavailable due to COVID, that worker is entitled to up to 2 weeks of paid sick leave at 2/3 their regular rate. So if they themselves are sick, 100% at regular rate. But if they're caring for someone else or they're caring for a child, just as a baseline, it'll be 2/3 of their regular rate. But for employees who have been working for the same eligible employer for more than 30 days, the FFCRA allows for up to an additional 10 weeks of paid family and medical leave at 2/3 of the employee's regular rate. So if they themselves are sick, 100% of sick leave, caring for someone else, but they have not worked for the same employer for 30 days, then they're only entitled of 2 weeks of 2/3 pay. And then if they've been working for the same employer for more than 30 days, they get 10 weeks in addition to those 2 weeks that are established as a baseline, up to effectively 12 weeks at 2/3 pay to care for someone who's sick or a child who's home. So on the next slide, we're going to deal with a paid leave hypothetical. This is a hypothetical employer who has less than 500 employees, is an eligible employer under the FFCRA's paid leave provisions. This is looking at 3 employees in particular, Allison, Brian, and Deborah. Allison has been working for the employer for 12 years. She has a 9-year-old son who's now home while school is closed due to COVID. Let's think about what kind of leave Allison is entitled to. So she herself is not sick, but she's worked for the employer for 12 years. She's caring for her son who's home while school is closed. So she's not entitled to full 100% pay. She's not entitled to the first type of paid sick leave that we mentioned in the last slide. But because she's been working for her employer for more than 30 days, and because she's taking off to care for a child who is home due to a school closure, Allison is entitled to 12 weeks at 2/3 of her regular pay. 12 weeks. The 2 that are established as a baseline, and then the additional 10 because she's been working for the same employer for more than 30 days. All right. So now let's move on to Brian. Brian's also been working for that employer for 12 years. Brian has a daughter who's home from university because of COVID closures, and his daughter is 19. 19-year-old daughter home from college. Brian comes down with COVID symptoms himself. What kind of paid sick leave is Brian entitled to? Well, he himself comes down sick. We go back to that first prong, that first type of paid sick leave. He's going to be entitled to 2 weeks at 100% of his regular pay while he's recovering from COVID. However, as it turns out, the information about his daughter or the fact that his daughter is home is a red herring for the purposes of this hypothetical, because the daughter herself, to our knowledge, is not sick, and she is too old to qualify for the paid family leave provisions. He is not entitled to any pay at 2/3 of his rate to care for his daughter. But let's say Brian's daughter comes down with COVID symptoms. Even though she's 19, the math changes a little, because now he's caring for someone else who has COVID. Under the terms of the FFCRA, in addition to those 2 weeks that Brian got at full pay for his sickness, now he's going to be eligible for up to 12 weeks at 2/3 of his regular rate because he's caring for someone else. The 2 weeks that are established under the baseline, and then the additional 10 weeks that are given to him because he's been working for the employer for more than 30 days rather. And finally, let's talk about Deborah. Deborah was hired by her employer 2 weeks ago, and she has a 3-year-old daughter who she's caring for while childcare is closed due to COVID. What kind of paid sick leave or paid leave is Deborah entitled to? Well, assuming Deborah is not sick, she is only entitled to 2/3 of her regular rate for 2 weeks. She hasn't worked for the employer long enough for the additional 10 weeks of 2/3 pay to kick in. Deborah herself is not sick, so she's only entitled to those 2 weeks of pay at 2/3 of her regular rate. But let's say Deborah's daughter comes down with COVID symptoms within these 30 days, before that 30-day window has expired. At that point, Deborah would be eligible for 2 weeks at full pay and 2 weeks at 2/3 pay. Oh, yes. And, but if she stays on long enough, if she remains through that 30-day window, and then her daughter gets sick, then Deborah is entitled to up to 12 weeks of pay at 2/3 of her regular rate to care for that daughter. It's a couple different variations here as we look at the different fact patterns for the different employees. On the next page, on the next slide, rather, we move into the information for independent contractors and the self-employed. The self-employed may seek a tax credit for mixed work. This manifests itself in a couple different ways. There's the qualified sick leave credit. The qualified sick leave credit allows someone who's self-employed to claim up to 100% of their wages, which is up to $511 per day. That's the cap. It should be noted, however, that you don't actually need to be symptomatic to claim the sick leave credit if you're an independent contractor or self-employed. You're eligible to claim it if you're unable to work due to an isolation order. So here, for this family sick leave credit, bit of a misnomer. Of course, that's what you claim if you yourself are sick, but if your business is affected, if you're unable to work due to an isolation order, this is also what you would claim as a tax credit to make up for that lost business. There's also the qualified family leave credit. Much like the system set up for employees with eligible employers here, the independent contractors and self-employed can claim 67%, 2/3 of their wages if they are unable to work while they're caring for someone else or for a child under the age of 18 who's home due to a school or childcare closure. Here, however, it's capped at $200 per day. So for qualified sick leave credit, 100% of the individual's wages, but capped at $511 per day. Family qualified leave credit is 67%, 2/3, but capped at $200 per day. Unlike the qualified sick leave credit, there's no hidden ball or any tricks when it comes to the family leave credit. That is straightforward. Just to emphasize, if you do lose business due to an isolation order, even if you yourself are not symptomatic, you can still claim that qualified sick leave credit as a self-employed individual or independent contractor. So let's come down to a hypothetical about an independent contractor under the FFCRA. So the same employer from our last hypothetical has been regularly contracting work with an independent contractor named Connie for the last 8 years. Connie is unable to work due to a local stay-at-home order, and at the same time, she's caring for her 6-year-old son whose school is closed due to COVID. Is Connie entitled to any leave under the FFCRA? The answer under the information we have is that she is not, but Because she's unable to work due to a local stay-at-home order, she is eligible for that qualified sick leave credit. Same hypothetical, still working with Connie. She's just been diagnosed with COVID. Now is she entitled to leave under the FFCRA? The answer is still no. Connie would be entitled to the same qualified sick leave credit that she claimed before when she wasn't able to work due to the isolation order, but there is no different treatment for when she's actually sick versus when she's just unable to work due to a stay-at-home order. It's all lumped into that qualified sick leave credit. No special relationship with the employer. He's not on the hook for Connie's sick leave. Nothing like that. Just a straightforward claim of the qualified sick leave tax credit. All right. Now we're going to transition to a different topic. That was paid sick leave under the FFCRA. This is employee retention credits under the CARES Act. Different statute, different provisions. To qualify for the employee retention credits under CARES, an employer must either suspend operations, fully or partially, during any 2020 calendar quarter due to a government order, or experience a significant decline in gross receipts during the calendar quarter. Just to clarify, in case there are any questions, significant decline here means 50% decline in gross receipts. So to qualify, the employer must suspend operations, at least partially, if not entirely, due to COVID, or experience a significant decline, here meaning more than 50% decline in gross receipts during the calendar quarter. So if an employer does qualify, what are they entitled to? What is this credit? Well, the credit equals 50% of qualified wages. Qualified wages is not necessarily a straightforward term. In addition to straightforward wages paid to employees, it may also include certain health plan expenses. So depending on your circumstances, you may want to investigate a little further. For employers who average more than 100 full-time employees in 2019, qualified wages are paid to an employee for time that she's not working due to the reasons listed above, either suspension of operations or significant decline in gross receipts. But if the employer averaged 100 or fewer full-time employees in 2019, then the qualified wages are the wages paid during any period of economic hardship described above. So during any period where operations have been fully or partially suspended due to COVID, or during any period where the employer is experiencing a significant decline in gross receipts. There is a cap on the ERC. The cap is going to be $10,000 per employee across all calendar quarters. That is, for these purposes, from March 1st of 2020 to January 1st of 2021. So qualified wages, the cap is $10,000, and that means, since the credit equals 50% of qualified wages, that the maximum credit is equal to $5,000 per employee. We're going to return to this concept in just a second, but did want to emphasize at this point that employers must choose between the ERC and the PPP. As Stephanie mentioned earlier, PPP is on a lot of people's minds. And as we get those issues sorted out, just keep in mind that if an employer claims PPP or takes advantage of it, they cannot claim these employee retention credits. However, if the employer has claimed or taken advantage of EIDL, an EIDL loan, an EIDL grant, they are still eligible to claim an employee retention credit. So you can claim ERC and EIDL at the same time, but not ERC and the PPP. All right, let's move on to the next slide, where we're going to return to this concept of the different kinds of maximum credits, different CARES Act hypotheticals here. So under the first hypothetical, employer one has experienced a significant decline in business due to COVID and successfully applied for an EIDL loan. Can employer one receive an employee retention credit? The answer here is yes. They can claim idle and ERC. But as we find out in Hypothetical 2 below, they had to suspend operations due to a state government stay-at-home order. They're taking advantage of PPP. Under those circumstances, the employer cannot claim an employee retention credit. That isn't because they were fully suspending operations. Rather, it's because they were taking advantage of a PPP program, loan or payment. So under that circumstance, if they had to suspend operations but it only had an idle loan, would not have been a problem. So finally, let's return to the math of the ERC. That employer pays Allison $10,000 in qualified wages during the second quarter of 2020. What is the ERC available to the employer for wages paid to Allison? So here, very straightforward. Allison has maximum wages allowed. Here, the employer claims $5,000. The credit, 50% of wages paid here, so half of $10,000, $5,000 ERC here. Pretty straightforward. But what happens if it's not quite as straightforward? So in the next hypothetical, we're going to deal with Brian, who we talked about earlier. So now the employer here has paid Brian $8,000 in qualified wages during the second quarter of 2020, and then $8,000 in qualified wages during the third quarter of 2020. So here, $16,000 total, spread out evenly across 2 quarters. What is the employee retention credit available to the employer for the qualified wages paid to Brian? All right, this one's a little trickier because there's an overall limit of $10,000 on qualified wages per employee. Brian exceeds that. So how does the employer handle it? Well, the employer's credit for Brian during the first quarter is gonna, or let me rephrase to clarify, during Q2 of 2020 is gonna be $4,000. During Q2, Brian's wages are only $8,000. He does not exceed the overall limit. You apply the 50% rule, you end up with a $4,000 employee retention credit for the second quarter. Then during the third quarter, Brian gets paid $8,000 again, except here he's gonna bump up against that limit. Now he's going to exceed the overall wage base that is eligible for a calendar year. So during the third quarter, even though half of Brian's wages would be $4,000, the employer is only eligible to claim $1,000 because that's where the cap for the calendar quarter is at $5,000. So hope that math was pretty straightforward, but it'll be a $5,000 credit overall spread out across $4,000 in quarter 2 and then $1,000 in quarter 3 due to that calendar year cap. Great. And then funnily enough, there is some interaction here between the provisions of the FFCRA's paid leave and the CARES Act's ERC rules. So is an eligible employer able to receive both tax credits for qualified leave wages under the FFCRA and the ERC under CARES? The answer is yes, but not for the same wages, right? So if an employer is going to try to take advantage of both of the programs that I discussed, paid leave and then ERC, they cannot claim the employee retention credit for any sick or family leave wages that were claimed as a tax credit under the FFCRA. So this goes back to the issue of what counts as qualified wages for purposes of the CARES Act, ERC, and as this example clarifies, it does not include any wages that were paid out as qualified sick or family leave under the terms of the FFCRA. I hope that was helpful.
Great, thanks so much, Zach. And thanks everyone for sticking with us through the overview for the programs. I know some questions have started to come in to the chat box, but we now have some time that we wanted to answer your questions that you guys have been hearing, or feel free to share other information as well in the chat box. So we'll let people start thinking and typing. We did have one question come through the chat box about how would independent contractors be treated under the employee retention credit. It's important to always remember that in the CARES Act, when they are talking about employees, they mean individuals who receive a W-2 from their employer. So if an employer is working with independent contractors, those would not be considered qualified wages. And so the credit is only available for employees that you are paying salaries to that are documented through W-2s. And in part of the reasoning behind that is because, as you can see, there are provisions for independent contractors and the self-employed in the CARES Act. So separating out the employers who receive W-2s from independent contractors and self-employed prevents double dipping. And so that's part of I think the philosophy or basis behind that. We might have overwhelmed everyone this week since it is tax stuff. The tax provisions are always more complicated as well. The unemployment, I know we've gotten some different questions. So as Tara mentioned, the unemployment programs are still developing. The expansion of unemployment to independent contractors, self-employed, and gig workers is new because these individuals normally cannot apply for state unemployment. And so there's going to be a lot of questions about how to document wages as you then go to apply for unemployment as an independent contractor or someone who is self-employed, because it's not as easy as just like showing them your last paycheck, right? And so there's still a lot of guidance that needs to come out that the states are wrestling with on that. So good, we're getting questions. So regarding assistance for independent contractors, are they eligible to receive a tax credit for mixed work if such missed work is voluntary due to physician conferred status of high risk? That's a good question. Zach and I can look into that more. Based on the plain language of the tax credit, I don't know that that would qualify because they weren't subject to an isolation order. But that's a very good question if they're in a high risk group.
I think Stephanie is exactly right in terms of just plain language looking at it, but I would like to add that it does mention that they are entitled to the credit if they are in quarantine, and it does not clarify whether that quarantine, you have to have symptoms for it to count as a legitimate medical quarantine. And we'll follow up about that. I think it could be yes, but again, don't hold us to that until we can follow up.
What documentation do we recommend for employers gathered during the next year ahead of filing their taxes next year? So I have to admit that I have not practiced law and didn't work in tax. Others on the phone might be able to help out with this. I think what you're really looking for is you're going to need anybody who's trying to claim benefits under the CARES Act and the Families First Act is going to need documentation of impact from COVID. And so however you can document that, whether that's information about income last year compared to this year, income about information about supply chain disruption. So any sort of documentation that you can gather that can help build the case that your business was impacted by COVID. And that would be in addition to all the normal tax documentation that an employer should be collecting. So W-2s, 1099s to independent contractors, payroll documentation, whatever their normal business paperwork is as well. Okay. Another question, seems like a self-employed individual has the option of using the Paycheck Protection Program or applying for unemployment. Which would be the better strategy? That's a very good question, and not something, I don't think that we can answer that as a blanket. It's going to depend very case by case. It could be that if they are eligible through state unemployment, that because of the plus up of $600, they may be able to get more money through state unemployment. But as Tara's slide shows, not every state is in the same place, and we don't yet know what documentation states may require for independent contractors to establish what their income is. Although that problem would be there with the PPP program as well. So it would take somebody sitting down and kind of running the numbers. So on our website, we now have the guidance from the SBA about how to calculate your maximum loan amount under the Paycheck Protection Program. And then you could sort of run the numbers with that and look at your state unemployment office's information about COVID and see how the numbers work, with the caveat that the PPP money is likely to go very quickly. And so we should be doing that soon. Oh, yeah, and as Kathy just typed in the chat box, the other thing to consider with respect to PPP versus unemployment, the PPP is a loan. Some of that loan can be forgiven, but not necessarily all of it, depending on what expenses the person pays with the loan. And additional guidance is coming out from the SBA on that. And so with unemployment, you would just receiving the unemployment benefit that you are entitled to under law, and not receiving a loan that you then need to abide by any of the forgiveness payments or repay the amount that isn't forgiven. Building on the previous question, do we know if one program, meaning unemployment or PPP, moves faster than the other? That might be the tipping point for some. Yeah, I don't think either one of these programs moves quickly. From at least what we've been hearing from news reports, some states have been able to process unemployment claims faster than others. And so that's really going to depend on your state. So it may be worth asking around in your state how fast unemployment claims have been processed, and whether and it definitely would only be an option in states that are currently accepting applications from independent contractors. The PPP is, as of today, out of money, but in the bill that passed the Senate yesterday, there are funds to put money back into those programs. The House is slated to vote on it by tomorrow, so there may be legislation by the end of the week. But probably getting back to the question, unfortunately, neither of these programs are likely to move fast enough if an individual has an immediate cash need right at this very moment.
I'd just like to butt in briefly, especially if somebody does have a very severe cash need. As there's been some conversation in the chat box about the funding situation of PPP right now, it is important to remember that, as Stephanie mentioned, there is a little bit of controversy with respect to how PPP applications are going to be handled. if and when the program is finally refunded or funding is restored. So with that in mind, if somebody's in is in a desperate need for cash and has not already submitted a PPP loan, there's at least a strong possibility that they are going to be moved to the back of the list when that funding is restored. So I'm not sure, quite frankly, how quickly these different state unemployment offices are moving through their work, but there is right now at least an abstract possibility that somebody without a PPP application already in the system might get frozen out if the next round of funding is also insufficient.
Great. Are there any other questions? I hope you found this helpful. We are planning on continuing to do these webinars. We have recorded this. As soon as we can get it up on the website, we will. Please send us questions. You can contact me by email or any of us. We'll do our best to find out the answers that you need information for. And we're trying to track the guidance as it comes out from the agencies. But as I mentioned, we're trained environmental lawyers. And so Department of Labor, IRS provisions, those are all kind of new to us, but so we're learning together. So thanks so much. And we may have another webinar soon on the new piece of legislation if it is passed by Congress this week. So have a great afternoon. Thank you.